Vivek, I'm going to start this session maybe once Sir is going to allow us, and then accordingly you can take over once the initial 2 or 3 slides or wherever my internet or bandwidth is low. Okay, so I'm going to like introduce you, and you can take over the session as well. Okay.
Okay.
Good.
Previous, can we start?
Yes, sir. Please start.
Yeah.
Yeah.
Good evening, participants. IEEE CS Madras, ACM Chennai, and CSI Chennai cordially invite you to a webinar on intellectual property rights and patents and filing guidelines by Mr. Saurabh Trivedi, co-founder and director, Boudhik Ventures Private Limited, and Mr. Vivek, investor strategist, mentor, innovator, and global business advisor. Patents, trademarks, and copyrights are collectively known as intellectual property and generally refer to the rights associated with intangible knowledge or concepts. Like any other property, it is liable to be stolen. So it is extremely critical for businesses and individuals to protect their intellectual properties, to focus more on innovation, research and development, and reap full benefits of their inventions. The broad coverage of the presentation will include importance of IPR, introduction to patents and how patent can be used to start a business, discussion on innovation model of Qualcomm 3M, importance of provisional application in US, India, and Australia, what is petty patents, what is innovation patents, and what is the utility model. How can we generate revenue from provisional patent applications? Mr. Saurabh Trivedi is an entrepreneur, intellectual property enthusiast, business consultant, investor, and seasoned trademark attorney. He is currently co-founder and director at Boudhik Ventures. Possessing unique set of skills and experiences allowed him to gain a quick understanding of industry processes. He is passionate and well-respected leader with the ability to define and drive business strategy, motivate teams, aggressively execute and analyze impact. He inspires and educates businesses on how to leverage their innovative concepts to stand out from the masses and gain traction. Legally advising startups on various issues related to intellectual property and has extensive experience in all aspects of intellectual property laws with special emphasis on filing, prosecution, and enforcement of trademark, copyrights, and designs. He also guides young entrepreneurs, startups, and early stage businesses to align processes, resource planning, and department goals with overall strategy. Also provides support and insight into significant organization changes, that is, shift in strategic focus and collaboration. His expertise currently include entrepreneurship building, consulting to universities, incubation centers, improvising, brainstorming of startups, multidisciplinary team building and leadership, IPR expert, strategic partnership. He is a member of Asian Patent Attorneys Association, India Group, and a member of Center for Education Growth and Research. Apart from that, he is a mentor in various Atal incubation centers that are supported by Atal Innovation Mission, Niti Aayog, Government of India. He also supports government initiative projects like entrepreneurship mindset classes. Mr. Vivek is an engineer, patent agent, advocate, and strategist. Over 13 plus years of experience in intellectual property domain. Vivek has handled 2,000 plus patent applications and assisted innovators, creators, entrepreneurs, institutions, and incubation centers in devising their strategies revolving around innovations, executing these strategies, and monetizing in accordance with focused marketing plans. The business-centric solutions provided by him enable stakeholders to maximize their return on investments. Mr. Vivek has been working closely with aggregators and accelerators in Australia, New Zealand, and Singapore, and helping his Indian clients in providing access to global markets as well as investors. Mr. Vivek holds ME in telecommunications from Loughborough University, Melbourne, Australia, BE Electronics and Communication from India, and Bachelor of University of Delhi. He is a registered Indian patent agent and a member of National Bar Association. Mr. Vivek is a director, Startup Buddy Services Private Limited, India, founder and director, Boudhik Ventures Private Limited, Adelaide, South Australia, co-founder and director, Boudhik Ventures Private Limited, India, intellectual property partner, Kaitaki Ventures, New Zealand, director, Nocio IQ Private Limited, Singapore, and core team member, Agricul, India. Over to Mr. Saurabh. Thank you.
Thanks a lot, Mr. P.V. Subramaniam. So the thing is that I would like to say thanks to all the organization IEEE IEEE, CS Madras, ACM Chennai, and CSI Chennai for initiating this webinar session on intellectual property right and patent filing and guideline. So I would like to sincere thanks to Mr. H.R. Mohan, Dr. P. Satyawal, who is IEEE CS Madras chair. So I would like to, what you can probably this focus on this intellectual property rights. I think sir has been introduced or given a brief introduction about myself. So I'm starting it how intellectual property is really important. Okay, so I would like to request Vivek just to move one more slide. Okay, just to given you a brief insights, what are the common types of intellectual property? Sometimes we are not understand which type of IP is required for my concept. Okay, and sometimes it's difficult to understand. Maybe we have written a wonderful code, but we didn't understand whether it should go under the patents thing or we can protect under the copyright application. So I'm starting it in a very brief manner as a wider level, but yeah, on a similar stage, I'm going to cover up once this presentation is move on. We are going to discuss each and every point in detail. Okay, so these are some common types of IP. I think we all are the audience are all engineers and from the technical background, from computer science background, so they understand these little bit technicalities involved in this intellectual property rights. Okay, so starting with common types of IP, everybody heard about the patents. Okay, I'm just giving you a brief about the patents. Whenever you have something technology, something involved as a innovative technology, and you have designed a very unique concept, and you think this is a very new technology, then we should go ahead and file the patent application. Okay, whenever we thought of having a very unique word name, logo, then we immediately thought of to file a trademark application. You have seen a wonderful McDonald's logo, Kingfisher's logo. So there are lots of things which is going to protect under this trademark intellectual property rights. Then another thing is a copyright. I already talked about coding part. Okay, when you have a wonderful design of your codings of your computer software program, and you thought where you have to keep it filed as a patent or a copyright, then I should say you, if you have a literary work, you have a coding things, you can go ahead and protect under the copyright application. Okay, the another very important thing is if you have a very unique product, okay, where looks of the product is really important for you to secure, you should go ahead and protect under the design application. Last but not the least is geographical indication. That has been when you have a very unique thing, any unique product with you, okay, and that is going to represent one geography, then it covers under the geographical indication. Okay, suppose you have heard the term pashmina, immediately that recall to the Kashmir, then you know that this is the product from Kashmir itself. And whenever you have heard oranges, immediately the territory comes into your mind is Nagpur. Okay, so that is when product is defining some geography, that is covered under the geographical indication. So in a brief layout, these are some common types of IP. Patents, when you have a very new technology. Trademark, when you have a very unique logo, wordmark, design, you can just protect under your trademark application. When you have any artistic work, literary work, coding work, you immediately go ahead and protect under the copyright application. When you have a product's looks is really important, you can secure in the design application. Geographical indication, we already talked about the typical oranges, pashmina shawl, and lots of other examples of geographical. Even the Rasgulla, which has been filed with the Bengal and Orissa. So that has been comes under the geographical indication. So these common types of IP, what exactly IPR gives you as an, what you can say, probably as an entrepreneur, as an professor, as a student, there are different types of stakeholders available in the market. Okay, they are universities, they are organizations, they are students, professors. So what kind of benefits you can get it from this intellectual property right? So I'm going to emphasize this. When you have intellectual property rights, suppose you have a patent application which you have filed. What exactly this patent application gives you is power. Power to eliminate your competitors. Okay, they are not going to copy it because they understand that you have already filed a patent application. So but you should have to file it, else somebody use it free. You don't have any power with you. So this intellectual property gives you a power. Second, very important advantage is credibility. Suppose, as you know, that all professors has to present something to their university, and where their what you can say, probably they are going to analyze on the basis of their patent application and giving some kind of recognitions to the professors. Okay, so same kind of thing, patents or intellectual property rights gives you credibility in the eyes of investor, in the eyes of the university, in the eyes of your peers, colleagues, wherever you are going to present yourself. Then this intellectual property gives you some credibility or maybe some kind of recognition. So this is really important. Then another important thing is, if you have intellectual property right, then you should do your business as well. As a professor, it's quite difficult for me to engage my 100% in the business activities. But if I do have a patent application, I do have a copyright application, it will easy for me to give somebody else to do the business on this. But yes, they have to give me certain value. So suppose you have a wonderful solutions, okay, and you have seen the problems which is facing by some organization, but that has been covered in your research, which you have done in the university premises. Okay, after that research, you have filed the patent application, you have filed the copyright application. Now your solution has been ready and protected. You should go to those audiences and ask, this is the solution of your problem. You want to take it, you can take it. You can pay me as in royalties. This is also covered under the licensing. When this business is something when you have going to sell your intellectual property to somebody else, and they are going to do the business, and maybe you can take some royalties one single time, some lump sum amount, or you can take some royalties. Another important thing is a valuation. You have 5 patent application, you have 2 copyright application, you have 1 trademark application, which is nothing to do with your business, but yes, you have filed just to do some business in future. Okay, and 2 design application just to protect your innovation. So you have entire IPR portfolio with you. They have certain values associated with them. You have heard about Google paid a less than $3.5 billion to purchase a Motorola's patent portfolio. They have not purchased the tangible assets. They have purchased the intangible assets because they understand the value is in the technology. It's not been in the hardware assets of the company. And that value is giving you something where you are going to innovate. Everybody heard about Kingfisher's logo that is having a certain value which somebody is going to purchase and take all the leverage, all the network associated with that logo itself. So that value is having some monetary valuation. So these assets, similar like a tangible asset, have certain values and comes under the balance sheets of the companies as well. Then another very good example is license. When you have a technology, you have protected it, you identify the audiences where this technology is going to use. You are going to outsource that technology to them, and every time you are just taking some licenses fees. The wonderful example where I'm going to take the example of Micromax and Ericsson. Micromax developed a wonderful market in India, okay, but they didn't realize that they are going to infringe somebody else's patents. Once they develop a territory in India, market base, everything is going well. After a certain period of time, Ericsson comes into picture and sue them that you are infringing my patent application. So it's really important, and this battle has been already 5 years long battle in Delhi High Court, and then Micromax loses, and then they are ready to pay the royalties on each mobile handset which is going to use the technology of Ericsson. They are ready to pay the royalties. But if somebody is having that patent application, they can leverage and they can pay as in what is the probably the royalties because they are going to use others' technology. Okay. Another example is others' IPR. Suppose you have done a wonderful technology, you have a wonderful product in your hand, wonderful coding, new concepts in the market, but you are not going to secure it under the intellectual property right. Okay. You have to check others' IPR. You have to respect others' intellectual property as well. It's not about whether you should go ahead, file and your intellectual property right, but you have to respect others' intellectual property right as well. The same example, like Micromax Ericsson, I have just taken it. Okay. Because if Micromax has to, what you could say, probably done the due diligence part at the very initial stage when they are initiating the infrastructure, they are going to hire the people, then they have to do the due diligence that somebody is having the patent applications or not. Okay. So we have to respect carefully others' intellectual property as well. Another, if very good advantage, if you have a patent application number, if you have a granted patent in your hand, if you have a copyright application, then it's enforceable. Enforceable means that you should write the specific set of claims, which I think probably going to discuss with by my partner, Mr. Vivek. But I'm going to talk about the enforcement when you have an intellectual property right. You can able to sue other companies who is going to infringe your technology, which is your what you can say baby product, or you have done that part. Another very important thing is when you have intellectual property rights, you get the filing receipts, like the same as in tangible products. When you have some tangible products, you have some owner proof. Then similar like in this intellectual property, you get some kind of acknowledgement receipt from the intellectual patent offices. Either you should file in India Patent Office, US Patent Office, Canadian Patent Office. You should receive the application acknowledgement with proper title. So this is really important that when we talk about the why intellectual property is important for us to focus, okay, or why I'm going to put some money in this intellectual property right. There are different key stakeholders which I initiated in my first what do you say when I introduced this discussion of intellectual property right. Universities, MSMEs, startups, professors, students. So this intellectual property gives the benefit to each stakeholders. Okay, but sometimes we just miss on or skip on our part. Why should I protect this intellectual property right? So this wonderful slide gives you the Vivek, can you just zoom it a little bit? So sorry for this inconvenience. The thing is that we talked about this different stakeholders, entrepreneurs, MSMEs, startups, universities, students. Okay, what exactly this intellectual property gives you? Okay, when we talked about this entrepreneur section, whosoever, I think nowadays this is a rat race where everybody wants to become an entrepreneur. Either it's been a student or any person, they just wanted to be as an entrepreneur. They just wanted to have a CEO's, whatever is probably the visiting card. They just wanted to present their identity. Okay, so the when you have intellectual property, there are lots of benefits. Apart from those benefits, what kind of doors should open for different stakeholders when they have intellectual property? Entrepreneurs should have intellectual property. They can easily grow their business because they are going to renowned in the market. They are going to presentable. They just increase what is probably their innovative products in their company's name. Another thing is they are going to collaborate very easily because they have something to share or something to what is probably the agreements in place. So it's very easy for them, and an investor is going to put money on them just to collaborate. Another, credibility of brand. If they have intellectual property, they have a very unique brand name. Even you know that Google's brand name is itself having some credibility in the market. We are going to sign some kind of agreement. If we get the name like Microsoft, Bosch, we are easily convinced and we are ready to sign the agreements. Okay. Franchisee possibilities. Yes, it's probably the similar thing. When I think everybody heard about the Nike, Reebok, or Adidas. They don't have a physical factory. They only have this intellectual property as a trademark owners of these names, and which help them to what is probably increase the number of franchises, number of business operation units open for them. Then, if they have intellectual property, they have some competitive edge over others. The other stakeholders, when I'm talking about the MSMEs, you know that there are lots of co-suppliers, the same kind of component to the organizations. Okay, but if suppose if some of the co-supplier is having intellectual property right, I think they are taking some extra advantage just to sign more agreements, more orders from the organization itself. And as all they are on the same page, but if one is having some intellectual property over others, they can have the competitive edge from their co-suppliers, generate higher revenue, because if you have intellectual property, they are going to less the liabilities of the company owners. So it's the possibilities of generating higher revenues because you are taking more orders, you are deliver their orders with having some credibility. Possibilities of international partnership. I am based in India and I don't know about the US market, Canadian market, or European market. Okay, but I do have a patent applications in different countries. So it would be very easy for me to find out a local person who is ready to take the license or take the ownership of my intellectual property and do the business. So it's really important because when I'm talking about the US, Australia, or Europe, they understand, they respect the intellectual property. But as an Indian person, as an Indian innovator, you should have to file the patent application in these territories where you think your business is more. Okay, and that is where your international partnership is valuable. Then credibility about PS, definitely that has been covered under the previous points. Benefits from government, you know there are lots of subsidies. If you have the patent application, you get the subsidy. If you have that trademark application or intellectual property rights with you, you get the lots of subsidies from the government side. The next important, I think everybody nowadays, startups, the person who initiated something on their own and they just wanted to stand up with their concept in the market, that has been known as a startup. But yeah, every organization gives some another definition related to the startups. The person who wishes to start something on their own. In 2000, what is it, probably in 2016, when government introduced or PMO introduced Make in India concept, okay, and Startup India concept, then the innovations comes into picture. Okay, everybody realized that I do have an innovative concept. I do have a concept which I should protect and get some credibility. So this is really important as for the startups point of view to get it on the roots. So the benefits are, I'm just what you can probably read those benefits, and then I just ask Mr. Vivek to brief it because I think we do have a shortage of time. Okay, so maybe audience can take a snapshot of this, and we will discuss this later as well offline. Okay, safeguard uniqueness of concept, 35% higher possibilities of success than others, higher possibilities of funding. That is really important. When you have a very important concept and you just wish to share it with investors, you are going to put that intellectual property in your pitch, and now you are going to pitch it to any investor. It is very easy to convince them because you have those assets in your hand which is having certain value. Then investor is ready to put some money. Because as me as an investor, my partner Vivek is as an investor, we can look around these kind of technologies or concept from the startups end where we can put some money just to accelerate their business. Then if you have intellectual property, you can get the monopoly, or it will help you easy expansion of your businesses. Another stakeholders are universities. They can enhance the reputation of intake of these students. And I think lots of universities nowadays advertise that we do have 10,000 patent applications. We do have n number of copyright applications. So this is really important for universities perspective as well to generate higher revenue by intake students, number of students. Apart from that, NAC accreditation, industry academia relationship when you have a patent application. Same like a student got admission in this scholarship. We do have that example with us. Wonderful student from India. They filed a couple of patent application and get a scholarship from US university. Then he is going to place there and doing their higher study. So it's really important for students' perspective as well. Ahead of job interviews, credibility at workplace, revenue generation from monetization of their patent application, a spin off from college to be the business owner. So these are what you say probably the lots of benefits when you have intellectual property. So we have to understand the importance of intellectual property rather than putting those kind of research in a journals. Okay, so we have to protect because the cost is very less to file this intellectual property applications. So I think Vivek, can you just move a slide, next slide? So I'm going to ask my partner just to introduce the patents and how this patent is used in a business as a tool. So over to you, Mr. Vivek. I think Vivek is arranging something technical great. So meanwhile, I'm going to ask the audience if they have any question, any query related to
Okay.
intellectual property. I think Vivek is here.
Sorry.
So Vivek, yeah,
Yeah.
you
Sorry.
can answer.
Actually. Yeah. Sorry. Now you can hear me. Actually, I was on mute before. I was presenting, so my presentation was on the screen. So now I will take up the further topics, and I won't be able to see the chat or the questions during my presentation, but we do have received questions from the audience. We'll try to answer them, each of them or most of them, and of course I will be able to take up the questions once I'm done with my presentation, and we may extend our presentation to some minutes. Please bear with us. And now I will start presenting my presentation. I will put the slideshow. Yeah. So and please prompt me if my slide is not there or my voice is not there. Okay. So, introduction to patents and how patent can be used to start a business. So, generally, patent is a most important tool for an innovator or a researcher, and this power of patent is such a high power, and it is though it's an intangible right, but it has the is the more power than any tangible rights. Okay, and it can give you a lot of revenue if I'm talking about a lot of return on investments in the research. So let me talk about the power of patent. Just see that there is a single innovator, Frank Ware. He's an inventor and patent attorney both. He had invented something and he filed a patent for that, and he got the patent. Like it's his patent is multicolored instrument lighting system. He sued Ford in 2005, and now he has sued Harley Davidson for the same, and he has been earning money on that. So this is the power of patent. If your patent is strong, enforceable, well thought, focused. So this person has focused his thoughts on a particular industry and he invented something. He got the patent and now he's suing. Suing means he is sending notices to these companies, big companies. And big company, he won one matter and he will be like winning the other matters as well. So this is the power of patent. Now, this is again is Harley Davidson has been sued by other companies also. But the thing is, power of patent. And why I'm talking about here a single inventor. This example because to relate to the audience. We are in our itself all are individual innovators in a group also as an university level also, but at the uh, very micro level, we are individual innovators. And what one individual innovator can do, this is the real time example. Now, so this is jeans, right? And everybody is using jeans. Everybody is wearing jeans. In my I will tell you my thoughts. When I used to see these copper rivets, I used to see them as a style, as an accessory in the jeans, to give them a look of rugged or rust feel, raw feel. But when I found the reason, I was amazed. A tailor used to repair these jeans, and he was having difficulties in getting the jeans in a place. Then he invented this copper rivets to make sure that jeans are being hanged properly, means in a stationary position. He didn't have the money for filing the patent. He went to the company owner, Levi, and told that this is my invention. Let's collaborate and file a patent. They collaborated together and filed a patent application. They got the patent and they enjoyed the monopoly for a number of years. So this is power of a group. You are innovators. Within a group, you can share the cost because, of course, cost is one of the concern why innovators don't file patents. So this is how you can reduce the cost. For example, a cost is 1 lakh. 5 of you can join, 20,000 each. Plus, you can generate a lot of revenue from it. So this is the power of patent for a group. Even a small thing can be patentable. Don't ignore it. Don't look for very high-end innovations. Yes, they are, and we all are capable of doing it. But in achieving that high-end innovation, don't let go the small innovation that we are every day doing. Maybe these small innovation can give us more revenue to do that high-end innovation, which will give me more money. So this is about the power of patent. And that's why I introduced this first slide, just to know that we are talking in real grounds. We are not talking in air. Patent is not a buzzword. It gives you money. Infringement matter already Saurabh has discussed. I'm not going to discuss because these are the few matters of patent infringement where companies get closed because of the patent infringement. They have to close their shops. Indian companies are suing Royal Enfield in US because they have a good patentable, they have a good patent in US. So this is always there, right? I'm just skipping it. This is about the success. When we talk about success in research or anything, we need to have these things in our mind. We should have the agility. We should have the understanding of the concept, acceptance of failure to keep us moving. We should be dynamic and changing according to the scenarios, understanding the customer. Most of the research, like in my personal opinion, and it's my personal opinion, that most of the research don't get through the market route because those research has not been started by keeping in mind the customer. They have been keeping in mind the research point. No, if I'm doing a research, for example, I'm working on a mouse, so I should not be start directly working on the technicalities. I should work on the market part. What kind of mouse is needed today, and what kind of mouses are required in the future? And then let's focus our search based on that need. Because if we file a patent, it will be valuable when the consumers are there to buy the product. Why Google brand value is so high? Because people are using it. Why Nokia was at that time, why Samsung is very high? Because there are consumers who are buying their patented products. So our research so start from the understanding of the customers today and future customers, and focus, strategy, all these things. In each and every point you need innovation. So innovation is the key. We all are innovators. We are great innovators, but we need to strategize that innovation. How to do it? which way we should do it. This is a very small case study. I, I will just touch base that what is the why like how a patent can do a good lot of good business. So in the first example, company A and company B. Company A used to be a market leader in a particular segment. Company B realized the importance of patent when they met the common customers. Customer asked them how you are innovative. They said we do this, we do this. Then customer asked them, show me your patent applications or design applications. It was done to them, with them in 2010. Then they started filing patent application and design applications. And within 5, 6 years, they're able to capture the 50% of the market share of the biggest company just because they filed patent application and design applications. Not maybe not been granted yet, but they capture the market. Similarly, in the company C example, they used to do innovation and give it to the end customer, and then end customer was giving to the consumers. They realized that they are doing a lot of innovations. They started filing patent application, and one of the patent application was really good, enforceable. It's still pending, but this company is still earning royalties from the co-suppliers. Their customer, sorry, am I audible, right? Their customer. Okay, sorry. So I will move on to the another case study of a student. So this is GreyOrange company. If you can Google it, you will find information about this company. So these are the two final year students all doing their final year project, and they went to a warehouse. They found a problem. Actually, I'm hearing my. Can you please mute yourself? You can Google it. You will find information about.
Can you mute all the participants?
Yeah. So this GreyOrange, the final year student went to a warehouse. They found a problem that it takes a lot of time for a person to take the new supplies into the racks and get the delivering order from the racks to the delivery point. They went to the lab. They built two robots, filed one patent application. From there, they started getting orders, and there's no turning back. This is quite old data, and they have now come offices in 5 countries. They didn't stop filing patent. Remember, as I mentioned, you have to keep file patent applications. From one patent application, they have generated substantial amount of money and contacts and orders. Then they started innovating. So innovation cannot be paused like what Nokia did, right? They paused the innovation. Kodak, they paused the innovation. They didn't realize what is there in the future, what consumer need in the future. So in this way, these students have generated a good company. I'm just taking an example, and anybody can go to the web and read about GreyOrange. Now, discussion on innovation model of Qualcomm and 3M. Before we get into the innovation model, and these are the two links. I will share this with you after our presentation. But just read the line. Qualcomm technology licensing business generated licensing 1.15 billion in revenue. They have reached this figure not in one day. It's a labor of years. And that's why they file thousands of patent applications every year. But are they patentable? Maybe not. But they are still filing patent application. The moment they realize this can be a patentable and there are 50% chances of getting a patent, they just file the patent application. Yes, they have the money today, but they must have started somewhere. 1, 2, 10, 20, 30. Then they moved on to 10,000 or something. So this is the target we have to keep for the universities. Like I have seen the participants that they are from a lot of universities. They can also do that. Companies also can do that. An individual innovator can also do that. Don't file 100 applications in a year. File 10. But they should be focused on the customer. You should have a clear-cut customer in hand before you start your research. I will give you an example shortly on this. So, innovation model of Qualcomm is using the patent database. So often people say that how we are going to know what we should innovate, what you should innovate. Don't go on the Google part. Go on the patent databases. Churn out the data of people or industries in your specific domain. See where that already the latest patent application, the innovation has been done. Take a clue from them and start innovating from that point. Don't reinvent the wheel. Use data patent database to catalyze. So these companies, Qualcomm and 3M, every quarter they have thousands of people sitting across the world doing patent landscapes and white space analysis. Patent landscape means churning out the data in the industry, what people are filing. White space is finding the white space between already done innovations and do the innovation in that white space. That makes your innovation valuable. Then you can do cross licensing. So these are the type of database. Please click a picture of this for your future reference. So objective of patent landscape. Who are the strong and weak innovators? Who are the newcomers? Who was there first with broad and fundamental IP? Who is partnering with who are litigators? Now, competition. They can be a collaborator. For example, you are sitting in India and you did a patent landscape. You found that one innovator is doing really good innovations in your domain. Call him up that I am in India. I have the market access of one of the largest consumer market in the world. Let's innovate together. Let's join hands. You enjoy your patent rights in your country. Let's file that patent in India as well. And I will enjoy, and we will share the licensing fee. We will share the revenue generated from the patent. In this way, sitting in India, you can have partner in a number of countries. So in this way, you can have collaborators. You can see you can if once you shortlisted your innovation in a patent landscape, from the patent landscape, you know which company is filing most patents. Make that company as your target customer. Develop something logical, prepare a provisional application, and go and sell it to them. Yeah. Then understand the technology. Get detailed insight into the state of the art. What are the current and past technology focuses? What will be the feature of tomorrow product? Identification and development of gaps and unique technical features. So pattern landscape and white space is the key if you want to keep innovating and want to innovate patentable plus commercially viable innovations. So these are the few more advantages. I'm not going to go into the detail of that. Benefits of patenting. Earn money by selling and commercialize your patents. Create barriers for competitors. If you are a partner as an innovator in a company, you can barriers. Bonus benefits, of course, is there that you're serving the public at large and you're providing solutions to the problems of the public. Like, for example, as simple as that, find a solution to a simple problem and file a patent for this, and you will get a lot of, I would say, revenue from it. So, mobile communication is also solving a problem. People want some wireless communication devices. So, the phones were invented, data invented, right? Internet, all those things are solutions of problem that we are facing, and we have 130 billion people. We have number of millions of problems. If we start solving them plus keeping globe in the mind, you can generate a lot of patents, a lot of solutions, and a lot of revenue. These are the few drawbacks of not patenting. I have seen in my own career that the research papers published by our Indian innovators been used as the benchmark for doing innovations, and those innovations are being done, and then patents were being filed, and they have been filed in India, and those innovators who were the researchers who published the researchers first are paying for the innovations they have done, because they didn't file patent for that. So you may have seen that researchers paper, like Indian origin researcher papers, are being read or being viewed most of the time, like in a very high volume or at the highest number. Why? Because it's in the world, people know that Indian researchers don't file patents. They just publish the paper. And that paper, of course, the technology is there. But that's a benchmark for me. I'm not copying that research. I'm I'm inspiring, getting inspiration from the thoughts you have mentioned in the paper. And then I'm preparing something. So this is how you can do. This is what we should stop doing it. Stop giving our innovations. See, I there have been a lot of debate about open source giving innovations to the public, but nobody doing it. There has been I can share one example that Tesla had made their patents public around 450 or something. Why? There is a reason to it. Because these patents were putting hurdles in creating battery market in the industry. And if there is more supply, people buy electric vehicles because they are cheap, because the patent technology is in the public domain. People will tend to buy vehicles. And once you are done, you bought the vehicle, of course, you are going to buy other products, other parts of the vehicle which are patented by Tesla. So this is the market strategy. Let's not get into the emotional part that, oh, such a big company has done this patent in public. That's good. No, there is a market strategy behind it. And we should understand as a researcher. So I'm not adverse to open source, but I'm more advocate toward, yeah. So my more towards do the patent. If you think that patent, yes, you have generated a, if you don't patent your innovation, from where you will get the money to do further research? You have to depend on government grants. Why you have to depend on government grants? Patent your research, license it to the big companies, then do a more further research onto it. Okay. Now, importance of provisional application in US, India, and Australia. Why provisional application? See, the moment you get an idea, I'm sure we don't have a substantial final logical solution. And we keep working towards it without taking the priority. Because if I'm in India today, there are 100 more people like Vivek working on the same concept across the world. And if they file the patent application first, they will get the priority. And I will not get the priority. I'm not talking about the grant. I'm talking about the priority. Who filed first? So they will get the priority. And my research will go into vain because I didn't file the patent application. I can share one example, live example happened with us. A startup who was working on flying taxis for 2 to 3 years. Very good concept. They didn't file patent. After doing the research, getting the product, good product MVP, they came to us for prior art search, means finding whether that is concept is novel or inventive. We found that similar kind of concept has already been filed as a patent before. But the date that they mentioned, the date of priority for that application was after that, but they didn't file the patent, so they didn't get the priority. So patent application priority is the most important. Important. That is the importance of provisional patent application. Now, why you file in India, Australia, US? For example, you're in India, you can file an Indian provisional application, right? Which I have shared on my screen. In India, we don't have to put claims. We just have to put a broad description. In US and Australia, we have to put claims. And for example, you have collaborated with someone in US and Australia, then you can push them to file provisional application in US and Australia because the investors, the ticket size of funding of the investors is high in US and Australia. Possibilities of doing the licensing of your product or your provisional application is high in US and Australia. So that's why try, if you have a collaborator, you have a US local partner, you should file a US provisional application or an Australian partner application. We do have some DIY tools for the innovators to file provisionals. The links are mentioned there. And for India, this is our, like, you will get the application number within this amount. And with seventh dot AI is a US startup which we are advising. And you, in USD 500, you can draft by using the wizard, and you can file it on your own. And in $9,000 throughout the year, you can draft and file unlimited applications. So for institutions or a group of innovators, for example, if you're 10 people, it's a $900 investment for the year, and you can start drafting. In this tool, you can also draft complete application, non-provisional applications also, and file it. It's there, like everything is within the tool. So, and Australia is, we are working on the tool, but yes, you can file a provisional application in Australia. So, just to understand the provisional, secure the priority date, and a provisional application can be licensed. This is happening in the west part of the world. I will show you one example. And this can happen in India also. But you have to move with the strategy. Now, I will take bit of filing procedure also. Like after provisional, you have to file a complete patent application within 12 months. If you don't file it, you will lose your application, you will lose your priority. So it happens that many of the innovators file 20 to 30 prior provisional applications, but they only file 10 complete applications because they just want to secure priority. And then after 1 year, they will say, no, okay, I will only move it 10. Let go 20 of them. That's an investment on securing the priority. Like booking yourself, booking your slot that, okay, I booked it. Now, within after 12 months, like you can decide which document you want to file further. These are the foreign filing routes. If you are doing a research, look at global customer in your mind, because the global, if your solution is globally acceptable, higher chances of getting funded, getting licensed, getting generating more money. Qualcomm is generating 1.15 billion from global, not just from one country. So it's really important you file. Most of the innovators, my advisory is go for PCT application. It gives you more time to file in other countries and negotiate with your potential licensors. These are the filing a patent application is a very simple process. It's not complex at all. It is very, very simple process. Only you need to have a good team. So, for example, there is a question like whether we should go to an expert for patent application filing or not. I would say I should share an example, and you can decide on your own. That, for example, there are good friends, two doctors. One is cardio, and one is dentist. So, cardio person has an issue with his tooth. He will not treat himself. He will go to an expert in tooth. Similarly, a dentist has a issue, like has a cardio issue. He will not treat himself for the cardio problem. He will go to the cardiologist. So it's about forming a good team of experts. You are expert in innovations, research, creating the breakthrough innovations. Your team member is an expert in how to streamline that process to make a patentable innovation and go to the market. If you join hands, that there will be more benefits to it, and it's not costly. You must have realized from the cost. And Saurabh and I have decided that we will be, since you all are spending time with us and hearing us, so we will be sending you very, very preferred cost, because the Boudhik venture, one of the objective is to ensure that each and every innovator in India file patent application and get some benefits, monetarily, credibility, like any kind of benefit he should get. So that's our purpose, and we will share our cost and all at a later stage, because there are few questions on the cost in the sheet, but we'll share the cost with everyone after the presentation. So these are the few simple steps. They're self-explanatory, and it's a very, very simple process. This is the in a figure like provisional application, decide about PCT application, and then in 30 months. Imagine you have 30 months to file in US. 30 months is a very large good period if you follow a good strategy. And what is the strategy? I will tell you the strategy in this section. Now, how to generate from revenue from provisional partner application? Look at the numbers. 2.94 billion in licensing revenue was generated in 2018 from the universities. Technology transfer. In our country, they are good institutions. As Saurabh mentioned, they are saying 1,000 patent applications filed. They are flaunting that we are the highest patent filers. But what next? Where are those numbers? Because people are getting into the rat race of filing patent applications. Don't file 100, 200 patent applications. File only 30 applications and ensure that 10 get licensed. That gives you more credibility. That gives you more, I would say, more honor that you have filed a patent application and they get into the. Look at the number 822 new products, 1080 startups formed. Like invention disclosures are the first part of provisional, 26,217. Out of these invention disclosures, I'm sure 20,000 provisionals were filed. And few of them are licensed and few of them, like, imagine if I look at the numbers, 26,217 invention disclosures, 17,087 new US patent applications. This includes provisional and non-provisional. So only 10,000 invention disclosure has been rejected in 1 year. 17,000 has still been filed, which is really important. License and options executed, 9,000. Almost half, almost half of them. I talked about one third only, but half of them get licensed. That is the figure we want to achieve with researchers. That is our purpose, to showcase this. And these are the real figures, and this is happening. And all these patents are coming to India, and we are paying for those patents in different products. Why can't we create our own? So how we can create our own? Like this. Begin project with doing pattern landscape in your area of interest. Do not dream it. Focus. See where the innovation is. Then file a provisional application by understanding the logic, and then conduct a technology evaluation. Means technology plus market. Go to the industries with your idea and report. Sell them. Get into the license part and begin with a new search. This can happen within 1 year. And this is strategy, and I will share you one example. This is the example. I think most of us are have been speaking in a lot of conferences, I guess. This is the issue. Everyone has to touch it. This becomes more prominent now because of the COVID. So simple, very, very basic problem. Nobody has thought about this solution. This is the solution we created. Put sensors, motors, develop an algo which detect the distance from mouth to forehead, so that this microphone keeps at the same level of my mouth, and that's it. This is the pattern application. This is the innovation of Team Boudhik. We thought of, when we came to this solution, we thought this might not be patentable, but we looked into it. We found it patentable. We filed Indian patent application, provisional patent application in 2018. After within next 1 year, what we did, we approached the biggest microphone manufacturing company. They immediately called us for the meeting, and they asked us to build a prototype. Yes, because of our lack in technical things, we could not develop the prototype in time. But that company is now thinking that our patent application has been lapsed and we are nowhere. And whenever the concept becomes public, they will use it. But no, We have filed international application. Now we are going to file this patent application in Canada, US, Singapore, Australia, and Europe. All the convention, all the conferences are happening in these countries. And every conference, every podium, these kind of microphones are needed where we are today. So this is, I will play a video. This is 3D printed now, quite old. So the final product is in making. Final product which looks like a good podium microphone. And we are going to launch this. So we found a very good partner in Hubli. They are working on the designing and electronics part. And we're going to start delivering this product early January. So this is how small problem. That's why I mentioned we filed the provisional, we approached the company showed interest. We could not develop the prototype. That's our drawback. But we didn't stop there. We moved on. We filed PCT application because we need more time. Now we have time. We are going to file patent application, and now this company utility design will be manufacturing and selling the products. And the maximum selling price of this product would be somewhere around 6,000 and 7,000. And imagine an export, I can increase the price. So this is how very small, problem solution approach. But before filing the provisional, we didn't thought anything. We just filed the provisional, blocked the idea. After that, we do the due diligence. Who is our market? Who is our customer? How to approach it? Whom to go with it? So we have all the market reports done after filing the provisional. We filed the provisional first. Yeah. So this is the live example. And that's why I mentioned earlier, we are talking about everything on the ground. Nothing is in here. Everything has been factually proven, factually supported. Now, patents and innovations utility model. Simple thing. These are the innovations, which are, I would say, incremental inventions. We don't need to prove inventive step in this for patentability. They are for short term, 6 to 15 years. And this is an interchangeable term: patent, innovation patent, short term patent, utility models. And importance of that is, for example, like in Australia, innovation patent is a term been used. It get granted after formal review, but you cannot enforce that. But why you need to enforce if someone is infringing? If you have a good patent, you get a patent certificate and increase the credibility of your company and your portfolio. And try and partner with someone there and say that I have innovation patent. Let's partner with it. But of course, you should have a confidence on innovation that if it gets examined, you will get a patent. So a good prior art search needs to be done before filing these utility patents also. So for example, in Malaysia, the furniture market is very, very, very promising. And a lot of moldings or foldable furniture has been exported from Malaysia to nearby countries, even in India. So they find a lot of utility models where the manufacturing has been done in Malaysia. In India, we don't have this concept. There has been a lot of voice among the innovators, but again, the government has not decided yet. It may or may not happen in India. So this is the utility model. The concept of utility model, innovation model is, for example, you looking for some kind of credibility or recognition. You can just file these utility models or patents in China, in Japan, in Malaysia, or in Australia to get those foreign certificates. Yeah. So this is the final thing. If you capture these benefits, focus your things by seeing that you want to reap these benefits, like physical assets, license, foreign collaborations, business expansion, and credibility among the consumers. These are the drive. You can use IP for these purposes. Yeah. And so this is where I end my presentation, and happy to take up questions from the sheet or or from the audience?
Okay, thank you, Mr. Saurabh and Mr. Vivek, for your excellent presentation and giving an overview about the patents, IPR, and filing guidelines. There is a request to just rerun the various types of databases, patent databases. Can you do that?
Sure. Hope screen is visible.
No, Vic.
No?
No.
Don't worry. I will do it now. Yeah. Now it is visible?
Yes.
Yeah.
So this is the databases.
Just can you
Zoom?
put it in the presentation mode?
Yeah.
And also explain a little bit about how to go about doing the patent search.
Okay. So let me try to zoom. So for example, I would recommend that you should use eSpaceNet, this one. This has 100 plus countries database. The moment you Google it or search, for example, Mohan sir, you want me to do a quick search on the database?
Yeah, that will be great. Yeah,
Okay.
that will be great.
Okay. Give me a second then. So I will open eSpaceNet. So this is the link, okay, and you enter your search term here. So for example, let me put drone UAV. Like, let me put drone for healthcare. Drone for healthcare. I got 1,347 results. Okay, and you can sort by relevance. If you can say publication date, if you put the publication date in as descending, this is the latest application published on 12th November 2020. Okay, and this is one of the granted patent just published on 10th of November. So if you click on one, you will get the biblio data, like which company it is. A system for arranging transport adaptive nutrimental artifacts with user-defined restriction requirement using artificial intelligence. So this 4 they have taken up, right, for arranging transport, but you will get this patent to understand your concept. You will be able to know, okay, this has been already granted, and this is the latest publication, robotic devices. So this device is talking about robotic semantic system includes one or more smart robotic device, which may be configured as a stack of modules, including mobility module, sensor module, variety of modules and communicate coupled. So this is talking about a kind of new robotic device. And this is the latest published application, not the patent. So this is the latest innovation, right? And so for example, this was filed on 15th of July 2020 and it got published very fast. So these are the innovations you can read. So whenever I end my presentation, I request everyone, make it a habit that every fortnight you go to these websites, search for the interesting patterns according to your domain and read them. Just read them and try to question why they have invented. It will give you a very good, I would say, an idea of how to innovate and how people are filing patent applications.
Okay. Thank you.
Thank you.
And there is a request from some participants who have registered from Bhutan.
Okay.
Do you have any information about patenting in Bhutan? Is it going to be different or they have to use some other country patenting application?
See, in Bhutan, of course, every country has a different, I would say, laws related to intellectual property. But again, in Bhutan, there is a patent of I. They have intellectual property office, but we can do one thing, like we can give you more detailed information over an email that how different India and Bhutan is. But again, there is a different office in Bhutan which you have to go through. So you have national
I,
offices.
Vivek, I just wanted to interrupt. So sorry. When we talked about the Bhutan, that is not a PCT member country. Okay, the laws of different countries, like Vivek mentioned, US PTO laws are quite different. Japanese Patent Office laws are different. Okay, how different they are? Like suppose you file the patent application in Japan, or suppose you file the patent application in Bhutan. Okay, they have their unique set of processes where after certain period of time, might be a 1 year, might be a 48 months. Like in India, it's a 4 years where you can like request for examination of your application. Same like in Japan, it would be I think 5 years that you should apply for the examination. So every country is having their own set of rules and regulations. Okay, in perspective of Bhutan, Bhutan is not a PCT member country, and PCT means a Patent Cooperation Treaty. Vivek has already given you a brief introduction about the PCT process, where you get the 30 months to file the application in US Patent Office or in European Patent Office. Some countries require the the traditional method of filing the application. Suppose you file the patent application in Bhutan, in India, and you wanted to file it in Bhutan, you have only the 12 months time frame to file it in Bhutan. Okay, you can't file the patent application in through the PCT mode. Okay, so this is something where you can get the difference in filing, because Bhutan is not a PCT member country. Okay, same like in Argentina, same like there would be a Pakistan. So there would be a lots of countries who have not become a party member countries in PCT. And PCT is known as a platform where you can get the extra advantage of time limit of 18 months. Otherwise, you have the 12 months time frame open for all the countries where you wish to file the application. 12 months is a regular process, traditional method. You can opt for that. You can file your application. The process remains the same. Once you apply the patent application, you get the examination of the application, you get the hearing course of the application, apart from the different sets of the application, which Vivek told, might be a utility, innovation patent, that is having a subject to the specific limit without examination or examination. So these are quite differences when you talk about the Bhutan, Nepal, or different countries. Okay, so this is a brief about the Bhutan as an application.
And I shared the link of Bhutan Department of Intellectual Property. You can go through the link, and I'm happy to answer the questions if any.
Sure.
Are there any difference in terms of patents which are examined? That is, the patents which are given after examination or without examination. Do they carry the same level of value, or will there be different?
No. So once the application is examined and granted, it is a right.
Okay.
Once it's not being granted, because this is a very particular question for innovation patent of Australia.
Yes.
So in Australia,
because we find a lot of people, they prefer to go and file the patent in Australia because they give the patents without examining.
That is innovation patent, actually. So why the innovation patent has been given without examination? Because that is an incremental inventions. And it is correct that people file innovation patent, but what next? If you have an innovation patent, look for a local partner, try to commercialize that. Because the most important example is that in Australia, in Melbourne, the world's second largest casino is there, Crown Casino. They have a lot of programs and algorithms and different aspects. So they find a lot of innovation patent. And the moment they see that someone is infringing that, then they get that examined and file it. Because let's not waste time and money in examination if you are confident on your innovation. Get the innovation patent, collaborate it, make a business out of it, and work on it. So that is the way one should look at.
Okay,
Same
what
like
happened?
another country, sir, एक और country, there would be named as a South Africa, where you can file your patent application by a PCT route as well, and they are not examining your application. They are going to give you the certificate in hand. Okay, so where this examination has not been happened, South Africa is also one country where you can file application.
Okay, in that case, what happens if similar idea is being filed as patent in some other country? Will there be conflict? How the conflict will be addressed?
Yeah. So if this patent has been filed after their innovation patent date, then that patent will be not novel. Means because the subject matter is already disclosed in it. Okay.
Okay.
That person will not get patent.
I see.
Yeah.
So which means that there is a global consortium is there, which will, that is in WIPO or something like that. TRIPS, is it?
The
Who
it's
is
not
controlling that? Who is controlling the global patent rights?
there is no global patent. There is no global patent rights. There is no international patent. So to get the patent, you need three things. Concept: novelty, newness, inventive step. It means it's not a combination of existing solutions, and industrial applicability. It's industrial applicability is always there, but novelty, newness. It has been compared with disclosures across the world. And similarly, the inventive step also been considered in respect of the disclosures across the world. This is to get the patent. However, once you get the patent, that right is only enforceable in India if it's an Indian patent, in US if it's a US patent. US patent cannot be enforced in India. Indian patent cannot be enforced in US. And there is no term called international patent. Yes, there is a term international patent application, which is PCT application, which helps you to buy time in filing application in other countries. But there is no term called international patent, and there is no common global body which governs any global patent rights. Every country has their own patent, their enforceability.
So which means some patented technology in some other country can be used without any license in India?
Yes, if that is not patented in India.
Okay. So which ultimately puts a lot of, what I say that difficulty for ideas, for a person to get patent from individual countries. So isn't it not that?
Yeah, that's why I mentioned. I give it the example of microphone. See, whenever we are doing a research, we should have a market and target customer in hand.
Okay.
And once you have that, you have Indian patent application and PCT. That doesn't cost much. Then you have 30 months to convince one target customer to give you money to file patent applications in other countries.
So normally these patents, it takes about 30 months to get the license. Patent approval, is it? What is the?
No. So in India, if you go via expedite route, you can get a patent in 8 months.
Okay. So then what happens that provisional patent you are mentioning that it is valid only for 12 months.
Yeah.
So what happens if if the 12 months period exhausted? So still you have to reapply or something like that? Or?
No, you can reapply, but you lose the priority. Generally, what like people do, they file a provisional application. They file multiple provisional applications, and after 6 months, after understanding the concept market, they let go few provisional application and go ahead with few of them, half of them ahead, and file complete application for them. So those are lapsed, they are lapsed. So there's a very good question in the chat box. Is published patent will get grant?
Grant.
So first of all, let me clear that whenever your application is published, you file an application, After 18 months from the first filing date, it has to become in public domain. That does not guarantee you a grant. And I have often seen on LinkedIn posts that I glad to inform that my patent has been published in the official journal. That is a falsification. That is a you can be penalized for mentioning this because this is your patent application which is published, which does not have any right. Your application needs to be get examined and get the patent grant after the examination process. So the publication of patent application, always say patent application is, it is patent application, it's not published patent. It is a granted patent which get published after the thorough examination. Yeah.
Can you briefly explain about WIPO, TRIPS, and WTO? I mean, what their roles and things like that.
Yeah. So see, WTO, TRIPS, and WIPO. WIPO is the main body which concerns about or make policies related to intellectual property. That is, WIPO is World Intellectual Property, and it communicates with TRIPS, like communicate the TRIPS, which has been with trade and a World Trade Organization, because because intellectual property is a business tool. It's a business tool. That is why it is being monitored or been jointly work with WTO under the TRIPS. So why this thing has come up under the TRIPS? Because they want to create a an healthy trade between countries and safeguard. Because what is the surety that I innovate something and I use that innovation in US and nobody copies it? So that's why this convention theories or patent theories been come that okay, if we want to secure, we'll give you patent rights in our country. You come and secure your innovation in my country and do the business. So uh, I'm not going to the definition of the TRIPS or WTO because that's not a major thing here. It is about how why WIPO is doing. Why what is the what is the main point? Core point is intellectual property is not a piece of paper. It's a business tool. It can generate revenue for professors, for startups, companies, individual innovators.
Okay.
And there's another question from Dr. Krishna Kumar. Why Australian patent is published faster than Indian patent? See, Australian patent is faster than Indian. It's all about each and country procedure. Australian innovation patent is published within 1 year, within 1 month, sorry. Not regular standard patent. In Australia also, it takes 3 to 4 years to get a grant. But in India, with expedite process, we have got a patent for our clients within 8 months without a single word of amendment. So it's all about your strategy. And there is a published patent have any API score or granted patent have. There is no API score in patents. See, we patent is totally different than research papers. Patent have citations, but there is no API score. So patent gives you money, protects your technology. Research paper can only give you citation and honor. That's it. And people can use your innovations mentioned in the research paper, which maybe in future you will be paying for that innovation. And there's another question. Uh, is patent office corruption free? I can't comment on it, right? So, see, patents are getting granted. The only thing is, my question is if your patent is valuable, if it's been filed with proper strategy, nobody can stop you to get the patent and to commercialize your patent. So whether it's corruption free or not, I can't comment on that.
Okay. There's a question regarding should we cross-check before applying for innovative patent in India, whether similar patent is applied in any other country by someone. Cross-checking.
Yeah, so cross-checking, the term is prior art search. So of course it is recommended, but not at the time of provisional. Why I am pushing on provisional? You just file the provisional because it's not that cost incentive. After filing the provisional, then you do the research and do the small logical prototyping and MVP, then all those things. Yes, prior art is important before putting more money into the invention in the patent process.
Where does this domain name disputes come in this? Are they in?
See,
See,
domain.
now there are a lot of issues coming up. Domain name.
Yeah.
So where do they fit in this?
So
Case?
domain names dispute has been handled by a different authority. That is an intellectual property, but it's been handled by differently. However, there's an overlap between trademark and domain. So, for example, if there is a trademark, and if there is a trademark and a domain is there, so the trademark owner can sue the person for not for using the similar domain. Recently, we had a case where the no-show IQ and Notion IQ was there. So no-show IQ was our trademark. We sued Notion IQ, and their company got closed. So you will not find Notion IQ today. They have moved on to different name. So trademark domain is there.
Okay, then there are issues like getting patents for software products. There is still the confusion is there. Can you elaborate on getting patents or copyrights for software?
Of course. So, for example, let me take the microphone example. In the microphone, what is the main innovation? The interrelation of sensors and motor and the algo, the software which is adjusting themselves. So that can be subject matter of copyright, but we didn't go for the copyright because copyright is a weak right. We went to the patent where the technology is there. So in future, whosoever is trying to adjust the microphone by any means, we can stop them. However, if we went for the copyright only with the specific algo, anybody can come up with any different algo. So that is the difference between patent and copyright. And so this is how I always say that for the computer software, don't say that is software is not patentable. It is patentable. Maybe not India, but in outside India. US grants a business method also, software also. In Australia also there is patentable. Europe to some extent. Think of global things. And in India also, not software patents, but yes, methods and systems are allowed. It depends how you write your patent application.
So there's
Sir, I think I just wanted to interrupt in between. The thing is that whenever we talk about the software application, like suppose in US that has been allowed, okay, but just to file the patent application because you are an Indian national citizen, okay, you have to file a first application in India or you have to obtain foreign filing license to file the application in different country where this software application are patentable. So this might be a question when you just wanted to file your software application that my target audience is seated in US or in Europe or in different country where these are patentable. Or otherwise, if you just wanted to file a software application in India, it might be a question comes under the, I think Vivek knows better, 3K or something like, which is an objection came to us. Okay, so it's typically about the strategies where you wish to file your patent application.
Is there any liability to the patent owners when their patent has been licensed to third party whose product fails?
No. See, for example, if you have licensed your patent to someone and they are not able to work on it, you just revoke or end your agreement with them and go to the other person. Brother,
No. The question is if the product has got some defect and then it is some damage happens.
So
the patent owner has no liability.
No liability, and it is to be mentioned in the agreement. Okay. If you are manufacturing, it needs to be mentioned in the agreement for sure.
Okay, and then this reverse engineering, is it infringement of patents?
Yes, to great extent. Because if you are reverse engineering, because patent has been been broadly written, and you have to be very careful because it is lethal. I can say that.
Okay, and can you explain something? What is compulsory licensing patent?
Yeah. So compulsory licensing is that if they're not, why patent is being granted? Patent is being granted. I'm talking about Indian patent law. that this patent, the innovation should be available to the public at large, should be available at the reasonable cost. And the patent must be worked in India. So, for example, if nothing has been done and the person patent is just sitting with the patent, he's not doing anything. It's been 3 years or more, and when I approached the patentee, he refused to give me license on a decent, reasonable cost.
Okay.
Then I can approach to the patent office, tell the patent office that I did my efforts. First of all, this person is not working the patent, it's not available to the public, not at reasonable cost, and he didn't give me the license at the reasonable terms. Please grant me a compulsory license. So that's the procedure, like hearings happened and all the documentation happened. And if it's decided in the favor of person who is seeking compulsory license, then the terms of those compulsory license will be decided by the controller, not by the patentee. And it's not that you will get the compulsory license for sure. No, there's a lot of thorough scrutiny has been happening.
So mostly it happens in medical and then pharmaceutical industry, right?
Uh,
Particularly when pricing of the drugs and medicines are too expensive. Particularly, I think it has been done in the case of cancer patients, for medicines, applicable to cancer patients
yeah.
in India.
Yeah.
So it can be even international license can be compulsory licensing can be applied.
See, controller has power to allow export, but again, you have to see whether that country has a patent for that product or not.
Okay.
Before exporting, you need to do a due diligence.
Okay. Right. There are a few more questions. Okay, is it trivial? Is it recommended to file for IPR and then start your business? Do investors give preference to ideas that have IPR secure?
Yes, there are now investor funds are coming up. Which first question is there: if you have applied for a patent or a trademark, if you have an intellectual property portfolio, then only you apply for funding to us. Otherwise, don't. So this is the level of awareness among investors are, because they need defensibility. If I put money in a product and that can be copied easily by others, then I don't have a monopoly. I don't have leverage in the market. So that is really important to have an IPR portfolio.
Okay. And nowadays, some of the publication of patent is collaborated with money. Is it worth? Some question
So
is not very,
again, it's not clear, but again, but
Yeah.
I understood. You can get your patent applications published, because see, what is the rat race I talked about? In the NAC tradition, they have an option that how many applications are published. You can get them published. So, and there has been a lot of I would say discussions in that how many patent applications you have. So people get published their patent application. So it is worth in sense of what is your need is.
Okay. There is one generic question. Why in India is the poor in patent application? In India.
Because we are very good in publishing research papers. See, the moment my research paper is published, I am happy with it. That's why we are poor. And the another thing is, everyone think that patent is a complex process. It is not a complex process. It is very simple process. Only thing, you need to have a correct team. And I take an example of experts. Yes, I'm not selling myself, but I am suggesting. If I have, like for example, I went to this UTD Hubli company to develop this microphone, because I know I'm not expert. I'm expert in bringing a thought on the paper. I'm not an expert to make it a reality. So that's why I went to UTD. So it's the same thing. So that's why we are poor. We have all the capabilities. For example, like as I can see that we 400 people have registered for it. If 400 people think, I'm sure they can think more, but if they think in 1 year, at least two concepts based on the real time problems, 800 provisional patent applications can be filed. And from Boudhik, you can use DIY tool and you can reach us. We can help you to file all 800, right? We don't have any issues.
Can you just explain how Boudhik Ventures can help our members?
Yeah, so for your members, as we have discussed, that we would be helping you in filing provisional applications, right? At the cost which we have mentioned in the DIY tool, we can help you in filing it otherwise also. But I prefer that you use the tool, which is easy from anywhere, anytime. You can just key in the concept and give it to us. We'll file it. Plus, if you want to file a complete application, or if you want to file a complete application, we can do it in a very, very less cost that we will share with everyone over an email and with the strategy for US also, for Australia also. And then we can help you in giving advisory on commercialization and bit of monetization. But of course, we need to know your objective towards it, because every person has a different objective. So Boudhik Venture is there to give you all. I would not say, sorry, Saurabh, I would not say that we will be giving you a discount or no. We will be giving you the reasonable cost where we can justify our efforts and where your objectives will be achieved and cost will not be a hurdle for you. Yes, Saurabh.
Yeah, Saurabh, you wanted to say something?
Yeah, I'm saying like when we talk about Boudhik Venture is going to support the engineers or to file their patent application, like how we are going to support it. Filing is not a big concern. Concern is here like how you are going to craft your patent application. Okay, and you are saying is a draft the proper patent application. Okay, because after certain period of time, might be a 2 years down the line or 3 years down the line, you realize the value of your patent application. It's not, maybe it's not possible for you to get the grant within 2 months or 3 months, but yes, once this application has been granted, there would be some kind of enforceability should attach. Okay, then it's probably where you can generate some revenue, generate some value out of it, then go for licensing or other things. So that is why Boudhik Venture assists innovators to strategize their concept. It's not about the filing. Filing is very easy task. Okay, it's just a mere paperwork. But yes, how efficiently, how effectively you can write your application, then the thorough search, it's really important where we came into picture and do these kind of things.
Okay, thank you, Saurabh. There are a few questions, very specific questions are there. So what we suggest is that we will be sharing the email ID of both the speakers, and the people can directly get in touch with them. Please make sure that you fill up the feedback so that, we will be communicating to the people who are filling the feedback. Now I would like to request Dr. Saktivel to propose a formal vote of thanks. Dr. Saktivel?
Yes, sir. Good evening to all of you. It is really a very useful and informative session for all the members of the Computer Society of India, IEEE Computer Society and the ACM. So on this occasion, I would like to thank on behalf of the IEEE Computer Society, Chennai Madras chapter, ACM Chennai Professional chapter, Computer Society of India Chennai chapter. We would like to thank today's resource person of the webinar on intellectual property rights, patents and filing guidelines, Mr. Saurabh Trivedi, co-founder and director, Boudhik Ventures, and Mr. Vivek Dahiya, investor, strategist, mentor, innovator and global business advisor for their excellent webinar and excellent clarification on about patents and related information. So thank you very much, sir, both of you. And I would like to thank Mr. H.R. Mohan, Chairman, ACM Chennai Professional Chapter, Mr. P.V. Subramanian, Chairman, CSI Chennai Chapter, and Dr. Ahila, Managing Committee Member, CSI Chennai Chapter, for their excellent and dedicated support in organizing this webinar. I thank Mohan sir, Subramanian sir, and Ahila madam. And finally, I would like to thank all the participants who are attending this webinar through Google Meet and Facebook link. Thank you, Ananda. Thank you very much. Thank you, sir.
Thank you, Dr. Saktivel.
Thank you, sir.
Before we formally close today's meeting, want to inform you about our future programs. On 21st of this month, we have a program on data science trends and opportunities. On 24th, we have a program on deep learning algorithms for cloud robotics. On 29th, we have one webinar on COVID-19, remedies from medicinal plants and environmental hygiene. So these are three forthcoming programs in this month. And once again, I would like to thank our resource persons, Mr. Saurabh and Mr. Vivek, for excellently presenting the overview about IPR, patent, filing guideline, and also clarifying a lot of doubts what we had. So we always look forward for your support in the future events, and also would like you to encourage our members. Basically the awareness is the one thing which is missing, particularly, and people are having some mind block that patent filing is such a difficult task. I think you have demystified the patent filing is just a mere paperwork, and subsequently you need to work. I think that mind block you have totally removed. Thank you very much for your excellent guidelines, and we really look forward our long-term relationship. Thank you very much.
Thank you.
Thank you.
Thank you.
Thank you, sir. And I think there would be a lot of questions in the chat box, but
Yeah.
we would be happy to answer that. You can reach us on the connect@bouldhikventures.com. It's a general email address where we can answer the queries. Or if any sort of IPR queries, we are ready to support you.
Yeah.
Okay, we are
So-
not going to charging you, just to guiding in. But
So
if
we'll
there
be-
is time extension,
yeah.
we will.
Yeah, we'll be sharing both of your email IDs so that people can get in touch with you.
Sure.
Thank you.
Thank you.
Thank you.
Absolutely, sir. Namaste.
Thank you very
Thank
much.
you.
Have a good evening. Thank you.
Thank you.
Bye, sir.
Thank
Bye.
you.
Take
Thank you.
care.
Bye.
Thank you, sir.
Thank you, sir. Thank you very much.
I think it's 7:45. I think long,
Yes,
one of the long session.
Yes, sir.
Went up well. I think very informative session.
Very useful, sir. Easy.